was the old version of the Academic Distress Commission. But that didn't mean there was legislation drafted. There was principles, ideas, concepts that needed to be reduced to writing and made into a legislative proposal. And that happened. And there was no effort, contrary to the arguments that I just heard, there's no evidence that there was an effort to prevent people from learning about that. There was a rollout of when they were going to contact sponsors. And we heard from Mr. Madrid, yeah, that's a typical part of the legislative process. You figure out, who do I need to talk to? When should I call them? Give them a call, express support. That's what stakeholders do. That's part of how we interface with the General Assembly to get a law passed. To somehow make that sound like it's a bad thing that people have a plan for the direction they want to go about getting in touch with their elected representatives to encourage the passage of a bill. I think that's the antithesis of democracy. I think that democracy involves people picking up the phone and calling the legislature. And if you do it as part of an organized plan, so much the better for you. That's how you get laws through the General Assembly. That's not a shortcoming. That's the way that the system is designed to work. But we heard things like dishonest cover-up. Well, I don't know if the court did. I can say I did not hear any evidence of a dishonest cover-up. I think the witnesses were asked, did you ever hear, we're supposed to keep this quiet? No, we didn't. We have to keep this hidden. No, there was talk about confidentiality in the Youngstown community. That wasn't confidentiality with respect to the representatives. There was talk about confidentiality in the Youngstown community and a desire to sort of roll this out in an appropriate way. But to say that that somehow violates the Constitution, there was no question that by the time they voted, every single member of the House of Representatives and every single member of the Senate understood that they were voting for an amended bill. It's not a three readings rule. It doesn't rise to the level of what we saw in Hoover. It doesn't even really, frankly, rise anywhere close to the level of what we saw in Voinovich, which the court has already said is not a three readings rule problem. Now, they say, we should have more debate. I think we heard from a lot of people on the stand that one of the problems has been they've been debating for about 20 years at the Youngstown School District what to do. And that during that time, the Youngstown City Schools have continued to fail for the students of Youngstown. And I want to be very clear. I take no pleasure in coming up here and talking about the shortcomings of the school district. My mother was a teacher in high school. I hate to see school districts that are not performing well. I'm going to talk about that because I think it's an important part of understanding the harm that would be visited if this court would enter the injunction that they're requesting. But I take no pleasure in running down, and I do not mean to run down, the Youngstown City School District. And I recognize that school district faces challenges. But I would respectfully suggest that it's possible that the time for debate may have expired and that the time for implementation and fixing may be upon us. With respect to their other two claims, well, wait, I actually want to talk because they did bring up that Alabama case, and I just want to briefly address that. Your Honor, I'd just like to give the court another site. I fully appreciate the 1931 decision that they cited the court in Alabama. Encourage the court to read it and make its own determination regarding the value of that. But I would like the court to read it in the light of a March 2nd, 2015 decision by that same Supreme Court, the Supreme Court of Alabama, talking about the three readings rule and explaining why the rule that it articulated in 1931 isn't such a good idea. And what it says is, it notes, and I'll give you the site, 2015 WL, so current, it's not in the report you got, WL 867926. And now the test in Alabama, today, quote, several state courts have held that a substituted or amended bill is not a new bill necessitating rereading where its subject is germane to the original bill. And then it cites a whole bunch of cases from different states that make that same point. That the way states and state Supreme Courts have understood this three reading rule is it germane? Is it in the same subject matter area, both the original bill and the amended bill. Is it germane? That isn't, I would submit, that differs from the way it's been articulated by the Ohio court, which is vital alteration. Same question. Your Honor, there are other two claims, and I want to turn to those very briefly, because I know they didn't elicit much by way of testimony. And I'm not even sure, with respect to the voting claims, they seem very collapsed to me, but it essentially seems to be some kind of claim that the local voters have been deprived of their right to vote for school board members, or their vote has in some way been diluted. Their papers and their argument today are still not entirely clear what the nature of their challenge is. But I'll start by noting that for those claims, the court needs to assume that this is a validly enacted bill. In other words, it's been debated for 3 years and this is what got passed. The question is, now these are substantive claims. Does the substance of this bill in some way violate a constitutional guarantee? The matter of passage does not figure in at all. So first, with regard to their argument that this bill somehow violates the right to vote for local school board, I'll note that to the extent that their complaint is that the CEO is going to take powers away from the local school board, and instead it's going to be the CEO that has the powers, or the Academic Distress Commission that has the powers, I'll just note, as we did in our papers, a quote from the Ohio Supreme Court in State XRL Ohio Congress of Parents and Teachers versus State Board of Education, in which the court held that Article 6, Section 3, quote, governs questions of size and organization, not the power and authority, of city school boards. That's the Ohio Supreme Court. The Ohio Supreme Court, in an earlier case, said boards of education, quote, have only such powers as are conferred by statute. So perhaps recognizing that the claim about, well, the power gets shifted to the Academic Distress Commission, I don't know if we're walking away from that. I didn't hear much about that in closing. Now they seem to be kind of trying to step sideways and say, no, really, that isn't the power. The problem is that the bill allows for, I think was the language that they used, allows for schools to be closed, and if that were to happen, then we wouldn't be able to vote for schools. Well, as this court knows, once you start talking about what bills allow to happen, if this, if that, budget contingencies, things that haven't occurred, we run into several jurisdictional doctrines, such as, for example, right. So if their challenge is a facial challenge, I don't know if it is or it isn't, I've been making clear to me. If it's a facial challenge, then they have to show that this statute is not capable of valid enforcement. If their challenge is instead as applied, which was starting to sound like it was, that, well, if they were to disband the schools, that could be a problem. Well, then I would respectfully suggest to wait until there's at least some shred of evidence that suggests that somebody's thinking about disbanding the schools. We are miles and miles and miles away from that right now, Your Honor, and that is not a right point. That's why I think in their papers they were focused on the